Good morning and welcome to the 16th meeting of the Health and Sport Committee in 2020. The first item on our agenda is our fourth public evidence session on the Forensic Medical Services Victims of Sexual Offences Scotland Bill at Stage 1. We will hear from two witnesses today on the provisions of the bill, including the retention service, evidence and some of the data protection issues. Can I welcome first of all to the committee Julianne Horsley, Secretary to the Criminal Law Committee of the Law Society of Scotland. Welcome, thank you for joining us today. Due to the challenges of managing a virtual meeting such as this, we're going to take questions in a pre-arranged order. I will start with the first question and then ask each member in turn to ask their questions and invite a witness to respond. I would ask, please, that questioners and indeed witnesses keep questions and answers succinct. And please mention members when you're on your final question, and if everyone could give broadcasting staff a few seconds to operate your microphone before beginning to ask your question or to provide an answer, that would be very helpful. We now move to the first questions, and I want to start with reference to the retention service and provision for in the cases of self-referral. And to ask Julianne Maudsley, is the Law Society of Scotland content that victims in these circumstances should be able to request that evidence collected for forensic medical examination should be destroyed, but that should be a matter for the victim. Julianne Maudsley.
Well, this is a very important bill because it kind of bisects the interests both of private law, public law, and obviously healthcare. And as far as retention is concerned, I think what is fundamental is that the victim or the person from whom samples are being obtained are clear about what is being obtained, why it's being obtained, and what it's going to be used for. And therefore, as far as it is their right to allow what's being kept. So I think a lot of this is about information, Mr. MacDonald. I've always been a very believer, as I would fundamentally as a criminal lawyer, which you would know me best as, is for clarity. So if you are clear what's being done, then I think they have the right to say yay or nay in these circumstances, because it's self-referral. We're not talking about a situation where it has yet gone to the police. That is obviously moved it into a criminal spectre where obviously the interests and the balance can be slightly different. Is that what you were aiming at, Mr. MacDonald?
Yes, that's certainly helpful to understand, but given some of the evidence we've heard, where a victim in those circumstances does have that right to request the destruction of evidence, for example, should there be a cooling off period applied to that right? Should there be a period of delay? Julianne Maudsley.
Well, thank you. My understanding is that from a scientific perspective, there may be a limited period for which samples might be live for the purposes of collecting evidence. I think that's a problem, and clearly you'll have heard from experts that will be much better placed than me, but my understanding is roughly it's 7 days. I think it depends what's being collected, but I understand exactly where you're coming from. A cooling off period maybe is a bit graphic, but the idea of here's the advice, think about it. And I think this is very much the role that you're going to come on to about advocacy. Who's there to support them? Who's the person that allows you to go out the room? After all, if we obtain information, medical information or something we don't understand, we often take somebody else. We go away, we think about it, we come back. So I think there is an opportunity for that to be done. The trouble is that maybe re-traumatizes them if you speak to them about coming back, having self-referred in the first place. There's something to be said for getting it over with. But as we can see with victims, their responses are very different, and until you're in the position you cannot say. But I understand about giving time, but I think it's just as much about support as perhaps the time. At some point they shouldn't be badgered into, well, are you going to change your mind here? And I think that's the danger. If you say, well, go away 48 hours, think about it and come back, do you realise after 48 hours it's going to be worthless after that. You've got this finite period of time. So I think there are a lot of issues there, but I do stress, I think it's about information. and support that must be given at that first point of self-referral.
Thanks. Clearly, you mentioned yourself the possibility that some evidence is only of value in terms of criminal investigation for a limited period of time, and other evidence is perhaps very bulky and takes up a lot of space. So in circumstances where evidence has been kept for a period but is due to be destroyed, should victims be notified of that in good time? When should they be notified of that? And should they be able to request that samples are retained even if they haven't gone to the point of saying they want to pursue a criminal case?
My understanding is that the proposal is to make secondary legislation to deal with the periods of retention, and various periods have been talked about there. I think the problem about when does it end, when do you draw a line? If you're retaining samples for up to 2 years and then automatically they're destroyed at the end of that 2-year period if nothing has changed, then I do think there needs to be an end. But that's probably my personal opinion. The trouble obviously for the person affected whose samples they are, it's refreshing knowledge. If they get a letter 2 years down the line to say this is about to be retained, destroyed unless you tell us otherwise, I'm not sure I think that's very complex. And I do think there's a point when it comes to an end, as long as the period is sufficiently long, guided by the professionals who are giving us an indication as to these time periods.
Thank you very much. I now call Brian Whittle to ask this. Brian Whittle. Sorry, my apologies. George Adam, my apologies. For once I have got the running order back, and it's George Adam who's next. My apologies.
Yes, there's no difference there, Convener. One of us used to be an Olympic athlete, another one comes from Paisley. But possibly if I could ask, good morning, Gillian, if I could ask a question with regards to storage of some of the items. We heard from Dr. Anne McClellan, who said the problem with storage of large items such as a duvet or clothing is it's unrealistic to take all of that on board for an indefinite period. Now I'd like to ask, does the Law Society have a view on the storage of evidence such as clothing and duvets? Should it be by the Health Board, or what should we do with these types of, and who should do it?
Julianne Horsley.
Thank you. I am aware of the physical problem of storage of productions. I think this is where you need to look at what the item is. You need to look at the rule of best evidence for the purposes of criminal proceedings. And on occasions, number of occasions, productions are retained that actually are not physically required in the future. Now, I think we need to differentiate between being physically required for the purposes of taking a forensic examination or for the actual item itself. And in most occasions, the item itself will not necessarily be required for the purpose, for instance, of criminal proceedings. There's a very well-known case about a salmon that had been poached and whether it was required. So often there needs to be a very clear decision taken. Why are we keeping this item? Are we keeping it physically because someone may want to examine it in the future, or have we extracted every evidential part from it for analysis and retained that evidential part, be it on slides or whatever? So I think that's the first question. There's a question of law there as to whether this actually is required, because clearly if you're keeping large items, it costs in storage, it'll be more and more complicated. But I'm not sure with the number of referrals, etc., that their numbers are so high that the productions would be so great. And in addition, whether the productions themselves are so enormous that it would cause a problem. But I think this comes back to guidance, not part of legislation, but the guidance that accompanies the legislation for those who are involved in seizing and looking at items and examining them. Plus, obviously, the prosecution authority can give advice, even if the case hasn't been reported, from time to time, whether something should be retained or photographs can be taken.
George Adam.
Thank you, Convener. Just finally, just to go on that, so Gillian, are you saying that the Health Board should or should not be required to store this type of evidence would there be a need for us to store this type of evidence for any length of period?
I think that's not a yes-no answer. And the reason I'm saying it's not a yes-no answer is I think there needs to be guidance to accompany the legislation that makes it clear what the questions the Health Board should be looking at when considering whether this needs to be retained. And what I'm saying is that advice could be sought on the once-off one that is perhaps not clear-cut. In general terms, some items may well require to be retained, but in the majority, I would suspect, once the scientific evidence has been extracted, photographs should suffice, unless it's particularly unique and you think that it needs to be retained for the purposes of defence examination in due course, if indeed there are going to be criminal proceedings. But I do think it comes down to guidance that would need to be drawn up by all of those interested and involved, and of course involving the relevant legal advice, because this does fundamentally come back to you do not want to lose a criminal prosecution because the item wasn't there for examination by the defence at the time when the defence required to look at it. That's about the interests of justice, and that's a question that can be seen coming further down the line. So I don't think it's a yes-no answer.
Thank you very much. Brian Whittle.
Thank you, Convener, and good morning, Ms. Horsley. I want to discuss timescale for retention. I'm thinking specifically around cases of historical sex abuse here, and how it can be decades later that a prosecution is brought to court. I wonder if does the Law Society of Scotland have a view on the retention period for evidence in cases of self-referral?
Julianne Horsley.
Don't have a specific view, because I think this is very much a case where you require to take the advice from the scientists and those involved in forensic examination. They're the ones that would understand the conditions that you require to keep items that may require to be examined in due course, and what can be extracted from them to allow the appropriate examination to be carried out. I've seen discussions of between 2-3 years. I have no reason, I'm not a scientist, I have no reason to dispute that. My only concern that maybe ties in with the question that you're asking is that it is important, in my mind, that this bill is future-proofed. So we're aware of advances in science that may well mean that the examination might be capable in the future, or there may be some aspect of DNA or some biometric data or information that may be obtained. So there is that balance, but I think the trouble with historic sexual abuse is a lot of it is, even if there was a self-referral now and it was reported for criminal proceedings in many years to come, I think there will be a limit on the efficacy of the actual product, the actual examination. And therefore, again, coming back to the point that I stressed about clarity, I think the advantage of perhaps having a clear period, but perhaps this could be looked at again. I mean, you may have a period that you could have under review, so that if the scientists were saying, well, actually, samples last for longer, that might be an appropriate stage to look at a longer period, but that would be some way down the line. I think this act or legislation is important at this stage, and a lot of it, and we stressed that in our evidence, was about monitoring and looking at what you're doing and taking on all these other areas of law that are being dealt with by the Parliament at the moment, such as the Scottish Biometric Commissioners Act legislation has just passed. So I think all that needs to come together. Does that help?
Brian Whittle.
Thank you. I don't want to put words in your mouth. I just want to be absolutely clear in my mind what you're saying here. I mean, my understanding would then be if the scientist said that, for example, I don't want to be too graphic here, but fluid retention can be frozen and kept indefinitely. Is that something that the Law Society would have a view on?
I think if you got scientific advice that what can be retained can be kept indefinitely or for as long a foreseeable period, I certainly don't think we'd be objecting, provided that the victim was told that information is clear. So I think you've got to be very much guided by the scientists as to how long items can remain effective. And again, you have a question of storage. ultimately, but that can always be reviewed again. I mean, I think indefinite is too long, but it might be it's so long that you would consider, or looking at the victims group's response, you might say, well, the usual time for reporting something like this would be within 10, 15 years. So you might have been able to put that period on if the scientists said that sample could be examined effectively at that time. I don't think we'd oppose any longer periods subject to the appropriate expert advice coming from the various parties.
Thank you very much. Alec Colehound.
Thank you very much, Camina. Good morning. Thanks for coming to see us today. I have a number of questions about processing and storing of personal data. Can I ask if the Law Society of Scotland foresee any issues in the bill in relation to the processing or storing of personal data?
We did have some difficulties ourselves with the data, and I think I really can't take it much further forward than what we said in original evidence. We felt that the bill did not really talk about data in any effective way, and it wasn't very clear to us that it differentiated between samples and data. And we stated clarification as to the position regarding data obtained would be welcome. Section 9 refers to transfer of evidence, but the definition of evidence at Section 13 does not include data. And we thought that the data impact assessment did not differentiate between samples and data to be obtained. And despite having perhaps had a look at some of the evidence so far, I'm not sure that that's actually been explained, and that remains, if you like, an issue for ourselves.
Would you and the Law Society, sorry, thank you, Camina. Would you and the Law Society therefore recommend to the committee that we, by amendment, and make that clarity in the bill, that we differentiate, as you say, between evidence, samples and data? It strikes me that that's actually quite an important distinction.
Yes. Sorry, I beg your pardon. Yes.
Yeah. Thank you. Straightforward answer. That's terrific. Can I ask about whether you believe there are any potential issues with continuity of evidence that the bill throws up?
Not immediately. Continuity of evidence is absolutely vital, and we stress that. And with my background as a criminal lawyer, I would say that. But every stage in the chain of evidence must be corroborated in a sufficient manner. There's nothing more frustrating than being unable to have an item or refer to evidence in court if the chain has been broken down. Now, clearly, those involved, the medics, the police, or whoever is involved, that needs to be very clear who has taken the sample at what point, and the continuity right through to criminal process, if that is being taken place, must be clear.
Thank you very much. I now call David Stewart.
Thank you, Julianne. What assessment has the Law Society made of the value of an anonymous DNA database?
Julianne Horsley.
Have not made any assessment of that. If that was something that you would wish us to look at, I would need to take it back to the relative committees and obtain their respective views. As I said earlier, very much this was looked at from the criminal law perspective with the support of our privacy and other committees. So that's one, if you'd like us to come back, we can certainly seek the views of the committees on that particular point.
David Stewart.
Yeah, thank you, Chair. I'm sure the committee would equal, and perhaps you could discuss it with one of your committees and drop the clerks of the committee a line on this. Probably a related question, so it may be the same answer. But what view does the Law Society have DNA samples being analysed without the victim reporting the offence?
Julianne Horsley.
I think that's a difficult one, because it very much, I would say, depends on the facts and circumstances of each case. We are aware that the person from whom DNA may have been extracted may not need to be a witness in a criminal proceeding. So I would say if the interests of justice are such that it overrides that factor in these circumstances, and that's why I say it's a case-by-case basis, that there are circumstances where that could happen. Yes.
David Stewart.
And finally, convener, the National Police Care Network argued there may be circumstances when DNA information be handed to the police for a wider public interest, for example, in the case of stranger rape when other victims are involved. Do you agree?
Julianne Maudsley.
I can understand the interests of justice requiring that, I think, I would say. And I think, again, it comes back to the interests of justice and that balance that we're all aware of the rights of the state against the rights of the individual and the circumstances and the greater need. So again, I'm afraid I probably refer to my earlier answer that very much is I can see the circumstances where that would be justified. Equally well, I can see they can't. So I think you need to look at it on a case-by-case basis, but there could be circumstances, yes.
Thank you very much.
Thank you.
Sandra Hart. I call Sandra Hart.
Good morning, convener, and good morning, Ms. Maudsley. I wanted to ask a question in regards to equalities. And I see from the submission from the Law Society, you mentioned equality considerations as paramount. So I just wanted to ask the first question. Is there a risk that the legislation may discriminate against people with learning disabilities who wish to access the self-referral service?
Julianne Maudsley.
I think that's a very interesting question. I don't think it discriminates against them, but I think what is vitally important is that the guidance with the health boards, the guidance with the police, the guidance with the supporters is very clear, and that a person who has learning difficulties needs to be supported at each stage of the process by the appropriate help. Now, I mentioned, I think the appropriate adult is one person that would be in the would normally be around the police station, and I wondered if there was a role of the appropriate adult in connection with people in such circumstances. But it's not so much discrimination as much as we must make the system be able to support them, to allow them to make the best choices with the best information available. And that's what I would stress. It wouldn't lie that the legislation itself is discriminatory as much as what are we going to do to support people like that, because we know they're vulnerable. And there was an issue, I think, raised in one of the submissions I saw to the committee about vulnerable. And this is a point that the Law Society ourselves are very challenged with. We are concerned at the use of the word vulnerable across both civil and criminal legislation, and what exactly does vulnerable mean? So I would go one stage further with your question and say the person with learning difficulties is representative of one area of vulnerability. There are others. How are we going to ensure that all these areas of vulnerability that we recognise as being more vulnerable, how are we going to support them to understand the self-referral and to make the decisions that they need to make?
Thank you for that. That's very interesting, very helpful. You did reply to the convener's first question in regard to advocacy and clarity and people being given the full information. So would you think the committee should push this particular part of vulnerability and advocacy, clarity and information to all, particularly people who are vulnerable in the various stages of it?
Yes, I think we highlighted with regard to the bill that it was an important bill and we support it, and the victims groups obviously very much support it. But on its own, it's only legislation. So I would say that all these aspects that you stressed are the ones that need to be there with a clear steer, perhaps from the committee, as the bill progresses through Parliament, as to these aspects being covered and supported. Because after all, those that are the most vulnerable in society may well be the ones that are more likely, possibly, to be the ones that are going to be seeking to make self-referral. And that certainly is clear. And with this lack of clear definition of vulnerability, some people are vulnerable today and they may be the perpetrator the next day. I think there are so many factors involved in vulnerability that this is an opportunity to raise awareness of the legislation, but make sure that advocacy, guidance and support are all available for the groups that you recognise are vulnerable and needing additional additional support isn't quite right, because it should be everyone gets the same standard, but we have to recognise that people do need extra help, they need extra time. Mr MacDonald referred to cooling off periods. Perhaps this is an example of where you take longer to explain something and therefore longer for people to process information and then make the decisions that are appropriate for them at the centre. You've talked about victim-centric. This is victim-centric.
Thank you very much for that. If I could just follow on in that in regards, we'll just use the word vulnerable, although there's lots of different aspects of it. Now, there could be possible issues relating to forensic medical examination of vulnerable adults, and in certain cases, some people are frightened to come forward because they're frightened of social work becoming involved. And I read somewhere about they may be put under guardianship. So, do you think that's one of the issues, or the other issues which would really prevent vulnerable adults from coming forward to self?
Julianne Horsley.
I'm probably not the best person to ask, because I'm not representative of groups of the vulnerable people who would be the best place to give you an answer as to what they would experience. Their clientele, those that are in their category, from coming forward. Certainly concerns, I mean, it wouldn't just be concerns about social work. It could be concerns because of language, lack of cultural understanding, background, community. I think there are a vast range of issues that could prevent people coming forward, family members, etc. So I think that would be a question that, looking at what prevents people from coming forward, would be a good issue to ask some of these particular groups that are representative of vulnerability. But I think there'll be a myriad of factors that perhaps prevent them coming forward. The important point, I think, is to stress that when they do come forward, in whatever way, that they are adequately supported. And I wouldn't want to see a system failing to give that adequate support. And in that, I would include lawyers, wherever lawyers may get involved. It's very appropriate that one size doesn't fit all, and you take the time and care and attention. And that perhaps picks up another point that we made in our submission, which was about education. Not only is it raising awareness, it's about education, and it's education for everybody. And in that, I include my own profession.
That's fine. That's my last. Thank you very much. Thank you.
I call David Thomas.
Thank you, Convener, and good morning, Gillian. My questions around sharing best practice and continuous improvement. The Law Society of Scotland commented on Section 11 of the Bill, which sets out the requirements of cooperation between health boards regarding the planning and provision of services for the purpose of securing adequate provision and continuous improvement in delivery. What is the view of the Law Society of Scotland on sharing of the best practices between NHS boards?
Julianne Horsley.
Again, I'm probably not the best person to ask that. I think this comes back to a point that I've always raised in relation to education, is that for best practice to prevail, there must be communication amongst those affected. So in other words, a number of territorial boards are all involved and will be involved in this bill. A number of them were ahead doing bits before, I'm aware of that. So there must be forum for those that are involved in sharing experiences, and that's why we talked about monitoring of the provisions of the bill, or as the bill comes in. I don't know how that monitoring would be done, but there must be opportunities for the health boards to meet together and exchange experience. But not only that, I am aware of all that information being pooled and then no doubt being distilled down as doctors, nurses, or those involved share practices to make sure that those that are being trained and are in these processes are benefiting from perhaps an innovative or creative process that's been developed by one of the territorial boards. But the boards themselves, and I'm not the expert in this, will have ways of sharing and going to conferences, etc. But perhaps there is an issue of looking at monitoring to see how the bill is working and to see how effective it is, because after all, that's the whole purpose of bringing this legislation in, is to make it better for the people whom it serves, i.e. the victims, and therefore us as the public interest.
Very much. David Torrance.
And my final question, how should continuous improvement be facilitated by legislation?
Julianne Horsley.
Legislation, once it passes, I think there does need to be an opportunity for review, monitoring, to look at whether the laudable aims of the bill as it was set out are being achieved. And that, in this particular case, because it involves healthcare and aspects of criminal law and other areas of law. For what purpose was this bill set out? It was set out for the victims. It was to make it clear. It was to make it better, to make it easier, to make sure they got support and help. So I think it is very much essential to monitor and to look at a review, a report, to see how well it's working in such period of time as you as a committee in Parliament in due course may feel appropriate. But I don't think it's important legislation, and some of you may touch on whether it should involve children in due course. And I know that there's mixed views on that. So I think it's important to see how this is working before you start extending it necessarily to other areas to see whether it was working, whether it worked.
Thank you very much. And Miles Briggs.
Thank you, Convener, and good morning, Ms Horsley. Thank you for joining us today. In your submission to the committee, the Law Society of Scotland stated that absent from the bill seems to be any provision on the ongoing monitoring and reporting of how well the delivery of statutory functions are going to be achieved. So I wanted to ask, in your opinion, what reporting of standards should be in place?
Julianne Horsley.
I think, again, this is one, I think there are standards there are means to report through the health boards as to how the standards are being applied. They can be reviewed and looked at. So I think fundamentally, when I was looking at standards, we were talking about the standards that we're applying with regard to the health board. So I saw that being a health board review or process that would be involved there. But again, I'm not an expert in how the health boards work, so that would very much depend on how they work. But certainly we felt that there should be a review or look at the standards and how they were operating, again with this view to maintaining the best practice and sharing of experiences.
Thank you, that's helpful. In your opinion then, do you think that the reporting requirement should be in the legislation around these standards so that we can find out what's going on in health boards as well, and that should be made to Parliament in a set time period?
Julianne Horsley.
Again, I don't think I'm probably the best person to answer that. I think that is a matter for the committee. I think that if boards have appropriate standards, it's not necessarily something that requires to be reported to Parliament, but I don't think I could take that any further. I think that is very much a matter for the committee in obtaining health boards and feeling what scrutiny and monitoring should be involved. Again, repeating the point about scrutiny and monitoring being something that I think is required in respect to the whole legislation. And I'm carefully saying that because I'm very much before you as a criminal lawyer from the Law Society of Scotland and not representative of any healthcare or medical background. So what I do stress again is I felt that absent from the bill was this business of looking at reporting on the overall effectiveness. Part of that obviously is the standards, but whether that is a health board matter, I think is a matter for yourselves.
Thank you very much. Miles Briggs.
No, that's very helpful. Thanks very much. I've got no further questions. Thank you.
Thank you very much. Brian Whittle, supplementary.
Thank you, Convener. I just wanted to go back to the timescale of retention, if I may. As the bill currently stands, timescale for retention won't be on the face of the bill, and actually timescale will be decided by Scottish ministers subject to an affirmative procedure. And I wonder if that creates a little bit of concern for the Law Society. Do we think there should be a little bit more clarity on the face of the bill in this aspect?
Julianne.
Hello, I think I've just lost my visual connection with yourselves, I'm afraid. That's it, it's back again. I'm sorry, I beg your pardon, I was now concerned with my computer. I had a technical issue. Could I ask you, Mr. Whittle, if you could repeat your question again? I'm sorry.
Of course, technology is a wonderful thing if it works. I think what I was asking really about was taking you back to the time scale of retention. As it currently stands, it won't be on the face of the bill, and actually it'll be down to Scottish ministers to decide how long that timescale will be, subject to affirmative procedure. So does that raise any concern from the Law Society? Do you feel there maybe should be a little more clarity on the face of the bill, given what the bill is trying to achieve?
Julianne Horsley.
No, I mean, usually we would be very much promoting that it should be in primary legislation, but I did understand the policy memorandum about needing to, there wasn't a consensus. I was happy enough that it would be by affirmative means before the Parliament after appropriate consultation with the relevant parties. So I think as long as it's subject to affirmative procedure, I saw that as being a perfectly appropriate use of that kind of procedure for the period of retention. Again, I would stress that once a period of retention has been agreed, there very much needs to be communication of that, and whether what you're getting at is that there could be a review of that period of retention at some period of time, that certainly could be the sort of thing that could be included in primary legislation. But I think secondary legislation in these circumstances by affirmative means would be appropriate.
Thank you.
Thank you very much. Thank you very much, and thank you very much for your evidence, which has been extremely helpful and well focused on the issues that the committee will have to consider going forward. And I think you've given us some very clear pointers as to areas for which the committee will want to take responsibility and take a lead. So thank you very much to Julianne Horsley, and thank you for joining us this morning. And we will now move on to our second evidence session.
Thank you.
Thank you very much. We'll now take questions from Police Scotland on the Forensic Medical Services Bill at Stage 1, and I welcome to the committee Detective Superintendent Filippo Capaldi. Thank you very much for joining us this morning. You will have heard, I think, the previous question session, and you will appreciate we will follow a similar format in your case. One of the issues which has caught our attention is the estimation included in the financial memorandum by the Scottish Government of what the potential increase in demand may be as a result of the new provisions in relation to self-referral. Can you tell us, to start with, Filippo Capaldi, do you or do Police Scotland believe that those estimates of the increase in demand which may result from the implementation of the bill are reasonable? Filippo Capaldi.
Good morning, Convener, and thank you very much. I think they are highly subjective, given the estimations that have been used. I know from personal experience that the self-referral process currently operating at NHS Greater Glasgow and Clyde and at NHS Tayside, the numbers are very low. I think it is highly dependent on the number of people who come forward for self-referral. And it's difficult to properly assess and articulate that. I've looked at the numbers and I've looked at the methodology, and it appears reasonable, although I do know the actual numbers for self-referral at present are low.
Thank you very much. You will know, I'm sure, and you will know from your own sources too, but certainly it's from the evidence we've heard, or the comments we've heard rather, from the likes of Scottish Women's Aid and other organisations in that field, that the current COVID pandemic and the lockdown has been the occasion for an increase in domestic abuse within households, and they've raised some real concerns about that going forward. In your view, does that have an impact on these estimates, and is that again a reason to reconsider the estimates of what the potential impact might be? Filippo Capaldi.
Thank you, Convener. In terms of reporting, particularly around the COVID pandemic, we've seen significant decreases over the last 11 weeks in the number of sexual crimes and rapes specifically being reported to Police Scotland, down around a quarter from what we would usually experience compared to this time last year. I think that will be a blip, so to speak, without being blunt about it. I think that those figures will increase. We know that, that these crimes haven't gone away, and I think subsequently when things settle down and we return to some sort of normality, then our reporting will increase again. So I wouldn't say that, that a reassessment is required of the estimates. I think from the estimations made, it's probably the most accurate figures that can be pulled together using the assumptions made in the financial memorandum.
Thank you very much. And I now call on David Stewart. David Stewart.
Thank you, Convener. Good morning, Superintendent. What assessment has Police Scotland made of the effect that self-referral for forensic medical examinations may have on the future reporting of relevant offences?
Philippa Capaldi.
Sorry, just to clarify, you are wondering around how that will impact on us operationally?
No, more on... Yeah, thank you, Superintendent. Just to clarify, has Police Scotland done an assessment of the effect on the reporting of, for example, sexual offences in the future once we've had self-referral for forensic medical examinations? Will this have an effect on individual victims coming forward and reporting sexual crimes, for example?
Philippa Capaldi.
I think the short answer is no. In terms of that assessment being made, I don't think it will impact on victims coming forward. This is, in effect, business as usual for Police Scotland in terms of dealing with victims of rape and serious sexual crime. I think we know, and you'll have no doubt heard from other witnesses to the committee, that these crimes are vastly underreported. We don't know the true nature of the criminality. So I think the reality is, no, I don't think that will have a significant impact on what we do day to day.
David Stewart.
Thank you for that. My final question is, when victims in the future contact the police about an offence such as sexual assault, will they be informed about the option of self-referral for forensic medical examination?
Philippa Capaldi.
Okay. Just to clarify, that self-referral means no contact with the police. It's for the victim to make that referral directly to the health board without police involvement. So, in effect, we wouldn't know if somebody had self-referred. We wouldn't give someone advice to self-refer if they're reporting to us. Does that clarify that?
David Stewart.
If I could, thank you. Just to give an example, Superintendent, in my early life in social work, I worked closely with the police about managing child sexual assault. And so I realised from my own personal experience in social work over many years that reporting rates are incredibly low, particularly within family abuse. So it's just a case of how well known will the option of self-referral for forensic medical examination be? And I assume it won't be well known, even after the legislation goes through. Will the police have a signposting role saying, have you thought about self-referral for forensic medical examination? If you haven't considered this, is this something you could discuss with your colleagues in Police Scotland?
Yeah, I mean, yeah, certainly that work is ongoing as part of the self-referral subgroup from the CMO task force. And a number of options are being looked at around the promotion of the self-referral process. And of course, we would certainly provide that advice for anyone who hadn't directly come to us, but in media campaigns or in documentation literature that we would display or give out to potential victims, that there would be an option of self-referral.
Okay, thank you
very much. Now call Alex Cole-Hamilton.
Thank you very much, Convener. Good morning. Thank you for coming to see us today. I'd like to ask a couple of questions about the storage and collection of evidence by health boards. Can I ask if Police Scotland are confident that the evidence collected and stored by health boards in cases of self-referral will be robust enough for your standards?
I think that will require extensive further discussion as to what measures are in place and what protocols and procedures that the health board have. I think it's difficult to ask doctors to make decisions on secondary evidence and what should be taken and what shouldn't be taken. I think we were clear in our submission to the committee that that samples obtained by doctors should really be limited to forensic samples obtained at medical examinations. I've heard from Julianne and from previous questions regarding the storage of certain items, which is problematic to say the least, particularly around conditions in which these items should be stored, how they are packaged, and what in fact do medics seize at that time from the victim. Do we limit that to clothing? Does that extend to bottles, cans, cups? Potential for DNA to be obtained from all or any of these items. So yes, I think there are some initial concerns about the range and nature of what should be seized and what should be stored. But I don't think these issues are insurmountable in terms of providing that advice and ensuring that health boards are aware of procedures that are required to store and properly package and retain that evidence.
Alex Cole-Hamilton.
Thank you for the answer. Does your organisation share the concerns then of the faculty of advocates that health board professionals may lack the necessary training in handling forensic samples and reports, potentially leading to the integrity of samples and reports being compromised? And further to your last answer, do you think that we need to underpin this with guidance behind the bill as to the sort of standards and training we would expect?
I suppose yes is the short answer in terms of the faculty of advocates. I've read their submission and they share the same concerns as ourselves and Crown Office Procurator Fiscal Service and in fact the Law Society as well. Again, I don't think these issues are insurmountable. I think through adequate training and provision of the correct information that could be done. Routinely, forensic medical examiners retain medical samples anyway. They retain these, in the correct conditions and packaged in the correct way. So, yeah, I think there are some initial concerns. I think that you talk about guidance. I referred to the self-referral subgroup earlier. And I know that work and those discussions, particularly around storage and retention of samples, is ongoing.
Thank you very much. Alex Cole-Hamilton, did you have a final question?
Oh, that was it for me. Thank you, Convener.
Thank you very much. Emma Harper.
Thank you, Convener. Good morning, everybody. I'm interested in some of the issues around the retention service, and we've touched on it a little bit with Alex Cole-Hamilton's questions. I'm wondering, Superintendent, does Police Scotland have any concerns about the type of evidence that could be collected and retained by health boards in cases of self-referral? We've heard over recent sessions about collection of duvets or even mattresses, and you've just touched on issues of drinks cans and things like that. So do you have any concerns about what evidence should be collected and retained by the health boards?
Yeah, I think we were quite clear in our submission that those items to be collected should be limited really to forensic samples obtained during the course of a forensic medical examination. I think seizing and retaining other items may be problematic. There would be very good reasons for doing that, particularly the likes of underwear, where there may be opportunities for forensic recovery. But I think we would have to have those ongoing discussions. But certainly larger items, asking forensic medical examiners to make an assessment of whether an item may yield further forensic evidence probably blurs the lines a little between investigation and the actual role of the forensic medical examiner.
Thank you very much. Emma Harper.
Okay, thank you. And just to be clear, that we know that the optimal time for collection of evidence is between day 1 and day 7, but forensic evidence like cells, fluids, samples for DNA analysis is better obtained as early as possible. But we know that photographic evidence is also critical when bruising and bite marks can then develop over days, actually. So I'm just wondering if you think that important evidence could be lost if health boards are not able to store the evidence, but we know that alternatively there are ways to store the evidence, like I mentioned, as in photographic evidence.
Yes, you're absolutely right. The optimum time frame is within 7 days for forensic recovery of evidence from a victim. Obviously, opportunities with other items like clothing, like cups, glasses, bottles, and these will last a lot longer and will enable forensic recovery in a much longer period of time. I think that the reality is that it's difficult to be able to provide that advice and direction because each report will be based on the circumstances of that particular incident. So we're asking forensic medical examiners to be detectives, to be investigators. I think we take the opportunity to retain as much as we possibly can, but I suppose the ultimate provision of the forensic medical examination is giving the option to the victim, but allowing the health and well-being of that victim to be catered for at that time.
Emma Harper.
Thank you, Convener. Does Police Scotland think there needs to be a national storage standard then across the health boards to ensure consistency in storage and then compliance with consideration for then presentation of the evidence as needed?
Filippo Capaldi.
Yes, I think there has to be. There has to be consistency of approach across all health boards, primarily to ensure that we have a robust process is sufficiently robust to ensure that any legal challenges could be repelled or could be accounted for. Further down the line, if a case gets as far as a court, there has to be a way to demonstrate and to audit a process whereby, as Julianne Maudsley had pointed out, that continuity of evidence and being able to corroborate each part of the chain of that evidence. So I think national standards are a very good starting point, and we'd certainly be supportive of that.
Very much, Emma.
Just my final question, Convener, and thank you for your responses so far. What information should be given to people about the implications of choosing a self-referral examination rather than reporting the incident to the police?
Filippo Capaldi.
I think it's about choices. It's about options. I think that advocacy services are best placed to do that and to do that work. I think promoting the service and promoting the availability and accessibility of that service is also important, and certainly Police Scotland have a role to play there in terms of signposting. But I do think that advocacy has a central role in the end-to-end process from point of report all the way through to potential court.
Thank you very much. I now call Sandra White.
Thank you very much, Convener, and good morning, Mr. Capaldi. I wanted to ask about transfer of evidence. I was very interested in what you'd said previously about self-referral would have no contact with the police at all, basically, and obviously corroboration to Emma Harper's question. The first question I wanted to ask is, what is the view of Police Scotland in the transfer of evidence from health boards?
Well, I think we would have to be assured in the first instance that there are proper and auditable measures in place for the storage and retention of that evidence. Thereafter, we would have to evidence the continuity, I suppose, in terms of the corroborated aspects of when that evidence was seized, where it was stored, who had moved it from A to B, and ultimately when we take possession of that, we have to be able to demonstrate not only to the prosecution but to the defence that there is the opportunities for that evidence to be tainted or to have been tampered with in any way, shape or form have been absolutely minimised in order for the court ultimately to accept the admissibility of that. Obviously, admissibility is a matter for the court, but in order to defend the processes that were followed, there have to be sufficiently robust processes in place at the outset.
Thank you, Convener. Just to follow up on that one, it came to my mind. Obviously, previously I was on the Justice Committee, and it was difficult to get evidence if you didn't have corroboration to policemen going to get evidence, etc. Do you see any difficulties with this particular part of the self-referral forensic evidence in presenting it to court? You did mention it had to be robust.
Yes, I think like any new processes that are implemented, what we're in effect doing or what's being proposed is something which is very new and will take some time to become business as usual. I think it's important at the outset to set a bedrock for that in terms of proper guidelines and proper processes and protocols to seize, retain, and pass that evidence to the police. I think if we can demonstrate that, then there's a credibility around the process. So I do envisage that. I think initially, like anything new, there will be some teething problems. However, further down the line, I think it will become routine and business as usual.
Thank you for that. I just want to follow up. Basically, we know that even the previous question I asked can't do anything unless it's reported to the police and the self-referral aspect of it. Now, would there be any advantage of Police Scotland being made aware that a self-referral forensic medical examination had taken place in terms of perhaps analysing crimes upwards or downwards?
Yes, absolutely. There's obviously intelligence information there, particularly, I think as mentioned earlier, if a passenger rape occurs in the community, it would cause specific or significant public concern. It would be beneficial to know that a self-referral report had been made. Again, I think it would happen self-referral process if we obtained detailed info of that, obviously to protect the rights and the anonymity at that point of the victim. But yeah, there would be value in that.
Just following on for that, maybe pushing it a wee bit further, there's been talk about an anonymous database, and you seem to be touching slightly on that obviously the police would be informed. It would be anonymous of the amount of self-referrals in regard to rape or serious crime. Is that something that Police Scotland would welcome, an anonymous database? Would that be helpful, not just in looking at how many crimes, but also helpful in maybe historical crimes as well?
It's a very difficult question. I think when we process items at our lab and we have a DNA extraction and we have a DNA profile, loading that to a database would probably necessitate a search against the national database. and you know, if we subsequently get hit on that DNA to a named individual, what do we do with that? Where do we go with that? There are benefits, but there are certainly some ethical issues around the storage and retention of that information for individuals, and it might very well be that that you know, would cause more problems than it would actually solve. From an intelligence gathering point of view, it's very, very beneficial for us. But then we would have to look on how we act on that intelligence and how we would then progress that particular aspect of the inquiry.
Yeah, that's lovely. Thank you very much for that. That's all, Convener. Thank you.
Thank you.
Thank you very much. And I call Miles Briggs.
Thank you, Convener, and good morning, Superintendent Capaldi. I wanted to ask a few questions with regards to advocacy, and you touched on this earlier when you were answering Emma Harper's specific questions. But I wanted to ask, do Police Scotland believe that advocacy services should be available to all victims? And currently, what's the model you use?
Yes is the short answer. I think since the establishment of Police Scotland in 2013, we have developed our very, very close links with Rape Crisis Scotland and offered advocacy at point of reporting to victims of serious sexual crime. We have significant benefits from doing that. I think a supported victim is more likely to be engaged with them, will stay engaged throughout the process. It's one aspect of that overall package of provision to individual victims. So we do operate a model with Rape Crisis Scotland. It's a self-referral at the point of reporting. We make that offer to every victim of rape and serious sexual crime, and we have to date found that to be very beneficial. I think moving forward is one of the concerns highlighted around the self-referral process. Again, we're asking a lot of medics, of doctors and or of nurses to be able to provide that initial advocacy support as well as look at the evidential requirements. And are we really asking that of doctors and medics, or are we asking them to focus on the health and well-being of potential victims and provide that early evidence capture as well as the ongoing health and treatment? So we would certainly, Police Scotland would certainly support advocacy for self-referral cases.
That's helpful. Thank you very much. One of the areas we've not been able to really pursue during the bill is with regards to same-sex victims. And so I just wondered, in terms of your experience, and what level do you think that currently stands at in Scotland? And currently, is the same advocacy provided to them as well?
Yeah, in terms of reporting, I don't have the stats to hand. I think we know from a recent look at our statistics for rape over the past years. I think it was 97% female victims and 4% male victims. So that's the kind of breakdown that we have at the moment. Again, what we do know is these crimes are vastly underreported for a whole variety of reasons. So the true numbers are not really known to us. But I don't think there's any differentiation with female, gay, bisexual, lesbian. Any victim of sexual crime is offering services via the advocacy support route, and we would make absolutely no, we wouldn't distinguish someone's sexuality on that basis.
Thank you very much. Miles Briggs, did you have a final question?
Yeah, thank you, Convener. You were breaking up during the evidence there in terms of the statistics, so you can maybe provide that to the committee after this session, and wider information would be useful. In regards to that then, do you think Police Scotland would welcome a statutory right to independent advocacy as part of this bill, or do you think that already is in place and so we don't need to legislate necessarily?
Filippo Capaldi.
I don't think that there's a requirement to legislate specifically. I think that existing agreements and existing alliances, I suppose, with the third sector, and particularly advocacy support services, are sufficiently robust, and I think it's probably more for the health boards to have that ongoing discussion around the provision of advocacy support at the point of self-referral. I'm relatively comfortable with what we have in place for matters reported to the police, but it's a self-referral that might be a small gap, and we've identified it early, so we should put provisions in place to fill that gap.
Thank you very much. And a final brief supplementary from Emma Harper. Emma Harper.
Thank you, Convener. It's just to pick on the point of the importance of advocacy, because I'm reading some statistics and about how in the Rape, Abuse and Incest National Network in the USA reported that 45% of rape is perpetrated by a person whom the victim is acquainted with, and 25% of rape is a current or former partner. So I'm assuming that makes it really challenging to prosecute, but also shows the importance of having advocacy to support the victims.
Filippo Capaldi.
Yeah, I certainly wouldn't disagree with those figures. I think from my own experience, familial abuse, familial sexual abuse is a significant problem, and we know, again, it's vastly underreported. Within the confines of sexual abuse, within the confines of close relationships, is also an unfortunately too common in terms of some of the reports that we get. I think that ultimately we would encourage people to come forward. However, some people will require more support than others, and advocacy play a key role in doing that and ensuring that people have the confidence and faith in the police and justice system in order to protect these matters.
Thank you very much, and thank you very much to Filippo Capaldi for your evidence this morning. It's been very helpful again. Apologies to those following proceedings that some of the sound quality was poor. We will check the official report. I'm sure both the witnesses will do the same when it becomes available, just to make sure that there are no gaps in what has been said. But I think that we've certainly found both Julianne Mosley and Filippo Capaldi's input very helpful. Thank you very much. That concludes the public part of this morning's meeting. The next meeting of the committee next week will be notified in the business bulletin, social media. And as previously agreed, we'll now take a short break, suspend the meeting, and resume by 10:15 in order to deal with business in private. I now suspend this meeting.